Good afternoon. Welcome to this SRA webinar to launch our Risk Outlook 2013. Your presenters today are Tim Livesley, Chief Economist and Manager within the Risk Centre. We've also got Laura Holloway, who's a Risk Analyst, and I'm Helen Apoggi, the Risk Coordinator. All three of us were involved in writing the Risk Outlook, and we'll be presenting a short summary of the report and also hosting a question and answer session. The presentation will last approximately 20 minutes, with the remaining time given over to your questions. Please feel free to submit questions in the text box on your screen as we go along, and you'll actually see that on the right-hand side, and there's a little box that says Ask. Please feel free to use this facility if you have any technical difficulties during the seminar. Okay, so today's webinar will cover the contents of the Risk Outlook, market drivers, SRA key risks, and our next steps now that Outlook has been published. Following our presentation, we will answer your questions, and we'll let you know when the Q&A part of the webinar is about to start. We may not have time today to answer all your questions submitted, but what we'll do is we'll collate some of these responses and publish these afterwards on our website. Okay, so what's in the Risk Outlook? Okay, so the document itself has two parts. Part A summarises the market drivers of the risk, and Part B presents the key current, emerging and potential risks to the SRA regulatory objectives. Before we begin, just a quick note that we'll be using the term firms to denote those entities delivering legal services, whether they are individuals in sole practice or larger firms, and whether they are solicitor-only firms, alternative business structures, or in-house providers. Okay, I'm going to hand you over now to Tim, who's going to give you a summary of the market drivers of risk.
Great, thank you. The first main part of the Risk Outlook deals with the factors in the legal services market which are driving change to the market and may be leading to changing or greater levels of risk in some areas. Our view of the market drivers has come from a variety of in-house and external research which we've been able to access, as well as direct discussions with solicitors themselves and our stakeholders to discuss what they're seeing happening in the market. So as far as possible, we've made it as clear and as authoritative summary of market change as we possibly can. So we've divided up our assessment of the market into four sections, the first of which deals with economic trends. There's a wide range of issues here, and I'm sure a lot of these won't be of any great surprise to you. The most notable one is, of course, the fact that there's been a significant economic downturn over the past few years, and one of the sort of interesting pieces of data that we were able to include in the Risk Outlook was a comparison of the current downturn with recessions in the 70s, 80s and 90s, and there's two particularly stark factors. One is the fact that this recession has been particularly deep. It's affected the economy quite severely, and then it hasn't been followed by a strong recovery either. And I think now, after a few years into this recession, we're starting to see the knock-on effect onto firms. We're also seeing changes in the HMRC's approach to drawing back money from firms that find themselves in arrears, and that's also having a knock-on effect from an economic performance point of view. And also the availability of credit. Although we've had historically low interest rates now for a period of time, firms are still finding it very hard to get finance, and that's also having effects on how firms are able to deal with the economic downturn. Another key economic driver is globalisation and internationalisation. This can present great opportunities for firms, but it also means increased competition at all levels of the market. It's certainly not just a trend that we're seeing for the biggest city firms. Then that takes us on to the next segment of the Risk Outlook drivers of change, which is markets, which is political and regulatory background. The key areas here in terms of political driven change are the reduction in legal aid, which we're starting to see already, and there's further reforms in the offering such as price competitive tendering. So there's key political drivers there which are having an effect on law firms. We also have the referral fees ban and other work around civil litigation reform. So there's some key drivers of change coming from the political arena. We also have regulatory change. Alternative business structures have been in operation for a period of time now, perhaps not long enough for us to see real market change in terms of levels of competition, but we're certainly starting to see a variety of different types of organisation providing legal services, which will have a longer term effect on competition. And we're also aware that it's been a time of regulatory change, and we've acknowledged that in the risk outlook, and we're also seeing further potential for regulatory change with things such as the recently published Legal Education Training Review, which will look at how skills are developed and updated within the market. The next section on market drivers deals with market and firm level trends, and here we've looked at exactly what's going on amongst the firms which make up the legal services market and the behaviours that we're seeing amongst them. We're seeing a large number of firms that have a focus on particular areas of work. Some of those firms will be specialists, and that's a very positive thing to see, but it's possible that other ones are fairly narrow in their focus, and if that area of work that they're focusing on is subject to restriction, perhaps legal aid or the conveyancing market over the past couple of years, we've seen those firms struggling to adapt. So not always having a narrow focus hasn't always been an advantage, and it's certainly causing the need to diversify for many firms. We're seeing increased numbers of mergers and consolidation, particularly with smaller firms looking to build up a stronger competitive advantage. We're seeing more firms commoditising their services, finding out which bits they can do in-house or with back office functions. We're seeing increased use of legal process outsourcing, technology becoming more available for firms to deliver services via, and also changes in the professional indemnity insurance market, which is also having an effect. The final section on drivers and drivers of change relates to consumer behaviour and expectations. There's a wide range of issues here. I think we're seeing more demand for fixed price services, and that's being met by several legal services providers. We're seeing more demand for unbundled services, where the firms are offering only parts of their offering to be provided by them and other parts to be done by the client themselves. There's a key question here about to what extent consumers are empowered. There's increasing amount of information available to consumers these days, but to what extent that really allows them to make assessments about the quality of legal services and who they should go to get the best deal for them, it's still not exactly clear cut. And we're also seeing some significant demographic changes in terms of an ageing population, a more ethnically diverse population as well, and all these things have a knock-on effect to the types of legal services which are demanded and how consumers want to receive them. So that's a short summary of some of the key drivers of change, and I'll now pass you over to Laura Holloway to talk you through some of the key risks.
Okay, so we hope giving you some detail of the market drivers of risk has given you a good overview of the current operating environment for firms and the SRA. I'll now go on to present our thinking on the key risks to the SRA's regulatory objectives. We came to our conclusions about these key risks by bringing together a wide and robust evidence base, from consulting staff across the SRA to reviewing external academic documents and analysing internal and external data. There is more information in the Outlook document about the sources we use to come to our conclusions. So I'm first going to talk you through what we're calling our current risks. These are the risks where we have evidence of a widespread negative effect on the regulatory objectives. There probably aren't any surprises here for the majority of you listening. The Outlook should provide you with more detail as to why the SRA is focusing on these areas, in particular the evidence of detriment to the regulatory objectives, including the public interest. The first current risk that we've got is financial difficulty. As many of you may know, the SRA has a programme of extended activity around financial difficulty that's been going on through the last few months, and on our website there is specific guidance around financial difficulty, including good and poor behaviours. We also have in the current risk category the dishonest misuse of client money or assets, the lack of a diverse and representative profession, and the failure to cooperate or comply with notification and information requirements. So those are our current risks where we feel that there is a robust and wide evidence base of widespread negative effect on the regulatory objective. Next I'm going to talk you through our emerging risks.
These are the risks where we have some but limited evidence yet of a widespread negative effect. These issues are growing as a concern, and they're things that the SRA feel have the potential to become current risks over the short term. The first one here is the lack of adequate succession planning or exit planning. This refers to planning for if a firm should close or if you would want to sell or succeed your practice. This isn't just about firms in financial difficulty who may have to close for financial reasons. It's also about things like retirement planning, about planning for unforeseen events such as long-term illness. Ultimately, it's about protecting your clients and past clients against problems that they may face if the firm closes in a disorderly way. The second emerging risk is around poor standards of service or advice, particularly where this involves vulnerable consumers. There's evidence from SRA research and research by our stakeholders that there are certain groups in society who may receive a poor standard of service or advice from their solicitor, and that they are particularly vulnerable to negative effects from this. And finally, inadequate systems and controls over the transfer of money. This is around the systems that firms have to protect against things like money laundering, fraud and terrorist financing. Finally, I'm going to talk you through our potential risks. These are the risks where we have limited clear evidence of the negative effects to date, but given current trends, they have the potential to have a negative effect. These are improper or abusive litigation, lack of due diligence over outsourcing arrangements, group contagion, and lack of transparency in complex business structures. Just to point out here that outsourcing arrangements also covers issues around data security, as when using cloud computing or initiating bring your own device policies, risk is being outsourced. Outsourcing isn't just about core services either. It could involve outsourcing your compliance regime or your HR services. Just to explain a little bit more about the phrase group contagion, we use this to mean when problems at one part of a group of firms may affect the other firms. So whether this is, for example, an ABS where activities in a non-solicitor part of the group affect the law part of the group, but this could also be a firm that has offices in various different countries, and if there were problems at one of those, are there sufficient initiatives in place to protect this from spreading to other parts of the group? In terms of lack of transparency in complex business structures, we just want to reiterate that this isn't specifically about alternative business structures. It may also apply to complex recognised bodies. So now that the Outlook has been published and I've gone over the key risks to our regulatory objectives, I'm going to pass you back to Helena, who's going to talk about our next steps.
Thank you, Laura. Okay. The SRA will be working to embed its findings into our regulatory approach. This includes SRA staff who will be referring to the risk outlook when they engage with firms, and also firms themselves can use the risk outlook to guide their own risk management, and to let you know that the risk outlook itself will be updated every year. If you'd like to know more detail as to how the SRA and firms can use the risk outlook, please let us know shortly by asking a related question. That concludes our presentation for today, and we hope you found it informative. This short presentation has outlined the key messages from the risk outlook, but if you'd like to read the full document and find out more information about our regulatory risk approach, please go to our website, sra.org.uk/risk. Or alternatively, we'd more than welcome emails from yourselves at risk@sra.org.uk. Okay, so it is now time for the question and answer part of the webinar. If you've not already done so, please submit your questions into the text box on the right-hand side of the screen. We regret that we may not be able to answer all your questions as stated earlier, but we will be providing a summary of answers to all the questions posed, and these will be available on our website afterwards. Okay, so what I'd like to do to start us off, I've got a question that I'd like to ask Tim. why has the SRA's regulatory regime, why is it not highlighted as a big risk in the outlook itself?
Yeah, we have recognised that it has been a period of big regulatory change, and we have made reference to that in Part A on the drivers of change and drivers of risk. So we've recognised that there has been a change in our regulatory approach from the rules-based regulation to an outcomes-focused approach, and that has meant that firms are having to think about compliance in a different way to that they used to. So we've addressed that risk we've addressed the risk associated with management of these changes by including regulation and political change as a driver, rather than saying it's a risk in itself, because we do believe that taking an outcomes-focused, risk-based approach is the best way to achieve our regulatory objectives. It's worth noting that we are conscious that regulatory burden and the cost of regulation we are aware that remains a high priority amongst the people who regulate, and it's also something we're very conscious of. I just wanted to highlight that our red tape initiative, the second consultation that we've run on that, closed on the 28th of June, so we'll be soon to publish what was submitted to us through that consultation. And through the red tape initiative, we're looking to scrap areas of our regulation which are putting a cost on businesses which can't be justified. So hopefully you will see the changes of that coming through fairly soon. So it is an ongoing commitment, and it is something that we're aware of, that firms have had to adapt to a fast period of change.
Okay, thank you, Tim. That's really helpful. I've got another question, actually. Do we have any plans to give advice to firms about how to manage these risks? Laura, would you be able to answer that one?
Yes, we are currently thinking about how best to engage with firms around the risks in the risk outlook. For the current risk of financial difficulty, we've already provided guidance on good and poor behaviours to help firms manage this risk. It's possible we'll take a similar approach with other risks in the outlook, so watch this space in that respect. It's also worth saying that on the risk website that you've been given details of in the slides, we have information about our risk index, which covers all 43 risks that we feel are risks to our regulatory objectives, and should give you a better idea of where the risks in the outlook fit within risk profile overall.
Okay, so we've had a question come through from Paula. She wants to know, what are the specific examples of problems with litigation? Tim, would you be able to answer that one?
Yeah, we've highlighted improper or abusive litigation as one of the potential risks in the risk outlook. It's the kind of problem where, when it happens, it seems to be quite a big issue. It gets a lot of press coverage. It affects a lot of consumers very severely. But it does seem to be the sort of thing which comes in isolated incidents. I think the most recent example that we could probably give, where it was what we would term as client exploiting litigation, third-party exploiting litigation, was the recent case of the work done about downloading pornographic material online and people being asked to pay money to have their cases prevented before they go to court. And that was a clear example of a case when the threat of litigation was being used to intimidate people who didn't have the skills to navigate their way around the legal system, and in that case it was clearly sort of being used in an improper and abusive way. And those are sorts of things which really undermine the interests of public faith in legal services. They really undermine basically public protection and the public interest. And it's the kind of thing which we just want to make sure that, yes, we're not seeing a particular scandal at the moment that we're particularly focusing on, but it's the sort of thing that we know that can always sort of show its head again. So we felt it was right to leave it as a potential risk, because those kind of things can always crop up, and we're always making sure that we're trying to keep on top of those issues when they do emerge.
Okay, thanks, Tim. Got a question from Tommy. Tommy would like us to briefly run through the potential risk of group contagion, which Laura mentioned earlier. Laura, would you like to go into a bit more detail?
Yes. The risk arising from what we call group contagion is that liabilities, losses or events affecting one part of a group of firms affect a regulated legal firm within the group. So this is things like is that with increasing consolidation, including mergers of firms, we're increasingly seeing businesses structured into groups of firms. So whether this is different offices in different parts of the country or different countries, or whether it's alternative business structures where there's legal and non-legal services provided within the same entity, group contagion is essentially about if something went wrong in one office or one part of the business, that there could be contagion from this part to another part. So what we've said in the Outlook is that the risk of group contagion will be greatest when members of a group are less integrated in terms of systems, controls, finances and decision making, but are still taking on the risks of the rest of the group. So this is about they're taking on liability and they're taking on risk with no control over the behaviour of the other parts of the group. I hope that's provided a good summary for you, but the risk of group contagion is fully explained in the Outlook on page 37.
Okay, thank you, Laura. It might be worth mentioning at this point that we still, it'd be great for you to still submit your questions for us to answer. So if you've got the opportunity to do so, please start sending them through now. Okay, and we've got a question that's come through from Eric. Eric wants to know whether we gave more thought about guidance to the additional burden of regulation raised by this report before issuing it. Tim, would you be able to answer that one?
Yeah, it's an interesting question. I think our response really would be that we think firms should already be doing risk management. We're not asking you to do anything new here. We hope this is actually an aid to your own risk management by letting you know what us as the regulator are really concerned about. So by all means, carry on doing your risk management as always, because it's important that you focus on the risks that are most relevant to your firm. But by having an awareness about what we think are the top risks in the market, hopefully that gives you an advantage because you can see what the regulator is concerned about. So by knowing what we're concerned about, it gives you a chance to flag up, are these things affecting your firm? Are there more things you should be doing about it? And hopefully that reduces the cost of having to deal with things if they become bigger issues further down the line. So while we are conscious when we put documents out, you do have to read them. There is time involved with that, but hopefully by being able to go through this and get this insight into what we think is important, it will actually be a big opportunity for you to understand what's going on from the regulator's point of view. And also I hope that it will mean that you can understand why the SRA is doing the things that it does, why we are spending a lot of time focusing on financial difficulty, for example. You can hopefully see that we're not being inconsistent in our approach. We have set out an evidence base here which says these are the things that are causing us big concern. One of the biggest concerns is financial difficulty, and hence you can see why we're asking firms in some cases to fill out additional information for us. And we're doing that to firms where we've got indicators that they may be involved in areas of work that have been under greater level of pressure. So again, we're trying to target that approach to make sure that we're doing it in a targeted risk-based way, which isn't spending the time of firms which needn't be too concerned with that. So I hope that answers that question.
Okay, thank you, Tim. We've had a question come through from Paula. Paula wants to know, are there any plans to revise Lexel so that the membership is indicative of good risk management? Laura, would you be able to answer that one?
Yes, Lexel is actually a Law Society initiative. It's a form of accreditation that they offer. We don't have any direct input into the content of Lexel. However, we do consult regularly with the Law Society on our regulatory regime and how that feeds into their work. I think it's also worth saying that the good risk management is something that's encouraged by the Law Society and that they have a lot of guidance about on their website. But it's also worth us saying that good risk management is something that we wouldn't necessarily think that if there was, say, an award like Lexel that meant that a firm had good risk management, that we wouldn't then do any supervision of that firm at all. We look at risk within the market as a whole, and whether or not a firm has Lexel accreditation, we need to be aware of how current risk in the market may affect that firm. I hope that's been helpful, but if you do have any more questions about Lexel, please contact your local Law Society representative and they should be able to provide you with more information.
Thank you, Laura. Picking up on current risks, one of the current risks highlighted in the report was a lack of a diverse and representative profession. And recently, the SRA has published an LETR report, and it'd be quite interesting to understand how the SRA will be taking that forward in conjunction with the risk outlook.
Okay, I'm going to pick up this one about the legal education and training review. And there are some key priorities for the SRA that have emerged from the legal education and training review. These are how to assure continuing competence, including continuing professional development, how to enable greater flexibility in the delivery of education and training by avoiding unnecessarily regulatory restrictions, how to improve access, equality of opportunity and diversity within the profession, how to achieve the right balance of responsibilities between the regulators, education providers, law firms and legal professionals. We'll be looking at how to incorporate these priorities into our work, including risk, over the coming months now that the report has been published. But I'd particularly like to draw attention to the priority of how to improve access, equality of opportunity and diversity, because as Helen has said, this does link through to one of our specific current risks around lack of a diverse and representative profession. And I'm now going to hand over to Tim, who's just going to talk a little bit more about what that means and why it's in our current risks.
Yeah, we've included this as a current risk because, well, if you look at the regulatory objectives, one of the regulatory remit that we have is to encourage a strong, diverse and representative profession. And although when we look at the statistics about people who work in legal services and who are entering the market, there are lots of headlines to show that it is, at some levels, a diverse profession. We certainly don't want to make it appear that it's not the case at all, because we do have a diverse range of people entering into legal services, which is very positive. But what we do see still is evidence of barriers to progression and other issues which might be stopping people from progressing up the career ladder. And it's not always entirely clear why that might be the case, but we can certainly see the effects of that in some of the statistics that we see. So we have a lack of women at partnership level. If you look at the representation of women across the profession as a whole and how many make it on to partner, there is a significant shortfall, and perhaps not one which is fully justified by the usual discussions that might be had around people leaving the market for family reasons, then returning to it. It still seems that gap is still far too big to be justified in any of the ways that are often discussed. So it is a concern to us. We also see evidence of a pay gap between BME, black minority ethnic solicitors, and white British solicitors. So we do see a lack of diversity creeping in there, and we also see some indicators which show that access to profession for people from less affluent socio-economic backgrounds may also be an issue. So we have underrepresentation of people from state school in the profession compared to public school. So there are still issues that we wanted to highlight as being important. We know that firms can't tackle those things completely by themselves. There's society-based issues, what are behind some of those things. Access to university, levels of debt at university and undergraduate level are all part of the problem. Lack of role models in the legal services industry for people from poorer socio-economic backgrounds may also be a key factor. So we know that there's some big society-based issues which we can't say that solicitors can deal with on their own. But at the same time, we know that we can do more to see better practices throughout the whole profession. So we recently published the results of a thematic review where we visited firms, talked to them about what they do to deliver the equality and diversity outcomes, and we published the things which showed good practice. We saw a lot of good practice in the firms we visited, and we published that in a report so people can learn off each other. So we're not saying that all firms are, we're not even saying the majority of firms are doing something wrong, but we are showing that there is best practice that can be used to improve equality and diversity within the profession, and we see that as our role to encourage that, as that is the regulatory remit that we have from the Legal Services Act.
Okay, I've got a question actually to Tim, picking up from that. In terms of the regulatory objectives, would you say, and this was asked last week at the Risk Outlook launch, would you say we're prioritising some objectives over others in the report itself?
Are we prioritising some objectives over others? Well, the Legal Services Act sets out the regulatory objectives, and it doesn't make any prioritisation of them. So, no, we haven't gone out of our way to prioritise any particular one. As far as we're concerned, they're all presented as objectives with an equal weighting. We did include an analysis at the back of the report which sets out which regulatory objectives we think the current, emerging and potential risks have the greatest impact upon. And by doing that analysis, we saw that the impact was greatest on the regulatory objectives of promoting and protecting the public interest, protecting and promoting the interests of consumers, and promoting and maintaining financial principles. So that analysis has shown that the risks that we're currently seeing in the market do seem to affect those regulatory objectives the most. We haven't made any decision in coming up with our assessment of risks that those are more important. It just happens to be that the risks that we're looking at seem to affect those the most. And that's possibly a result of those probably being the most broadly defined regulatory objectives. The other ones, like the one I was just talking about the diverse, representative, strong profession, it's more specific in the way that is phrased as regulatory objectives. So you will probably see less of our risks directly affecting that in the same way as you might the public interest, which is clearly a lot broader.
Okay, thanks, Tim. We've had a question come in from Asan. Asan wants to know, does the risk outlook apply equally to in-house lawyers and local authorities? Laura, would you be able to answer that one?
Yes, I think this question is good in that it allows me to pick up on the fact that the risk outlook is primarily about risk to the SRA's regulatory objectives. It's not specifically about risk to firms. So you will be managing the risk within your own practice in terms of protecting your clients, the viability of your firm, and this also applies equally to those working in-house and at local authorities. However, the risks in the outlook aren't necessarily all going to apply to every firm. There's some issues within the outlook that obviously are more likely to crystallise and present themselves at what we might think of as a traditional solicitor's firm rather than for an in-house lawyer or at a local authority. However, we do feel that a lot of the things raised in the outlook can be applied to in-house lawyers, and it's worth saying that in terms of collection of evidence for the risk outlook, we have conducted some research into in-house lawyers and spoken to in-house lawyers themselves to get their views on what's going on within their market and what type of risk they're seeing. I would say that particularly issues around providing advice that may affect vulnerable consumers might apply to bodies like local authorities, because obviously they do have safeguarding duties in terms of vulnerable clients. And so although the in-house lawyers may not be providing advice to these consumers directly, they may still have an impact on vulnerable clients because they may need to think extra hard about how the advice they provide to their employer may have a potential knock-on effect for vulnerable clients. An example of this might be the fact that within some practices that we looked at where poor advice was being provided to clients with disabilities, that for example, hard of hearing consumers were being charged for the use of an interpreter. The advice that in-house lawyers provide at local authorities may be able to address some of these issues, and the evidence provided in the outlook may help you see how this type of issue may apply in the role that you're in. Other issues such as group contagion may also have a special meaning for you, in that if you work at a local authority and there's a problem related to in-house lawyership at another local authority, it may have a reputational impact on you. You may not be thinking about group contagion in the traditional sense that if failure in one part of a group affects another, but in-house you probably are susceptible to reputational contagion if in-house lawyers at similar bodies are associated with poor practice. I hope that's helped pick up on some of the questions that you had. But in terms of how the report applies to in-house lawyers versus traditional firms, what you should be doing as risk and compliance staff is looking at this report and thinking, well, how does it apply to my firm specifically? Not all the risks are going to apply, and not always in the traditional way that they're presented in the Outlook. So how we intend for firms to use the Outlook is to use it as a guide as to what we feel the risks are, but then to take that positive step of identifying, well, what does this mean for my firm?
I just wanted to add on top of that that the SRA has been carrying out research into the makeup of in-house lawyers as a key sector of the market. We now have over 25,000 practicing certificate holders who work in-house, so it is a huge, and our research has shown that it's going to continue to grow a section of the market. So we'll be publishing that report later this summer, and hopefully that will give some more insights into how we're seeing that market developing. And I think I can understand where that question comes from, because I imagine if you're an in-house lawyer and you're looking at this, a lot of the risks may not seem directly relevant to your day-to-day activities, but I think Laura's hit the nail on the head in that we'd expect an in-house lawyer to use this report in the same way that any other solicitor would, in that you'll look at it, see what's relevant to your particular firm, your particular job, and then make sure that you're managing those risks. And you may find that there's less within this which is relevant to you, but I think that probably reflects that because of the lack of direct client-facing activities, risk levels from our perspective are often a little bit lower than they are in other sectors of the market.
Okay, that's great. Thanks, Tim. Okay, we appear to have answered all the questions sent through to us. So what I'm proposing to do is we'll end the session there.